Hello friends, welcome. In this video, let's learn about writs issued by Supreme Court as well as High Court for enforcement of fundamental rights. Supreme Court issues writs under Article 32 and High Court under Article 226 of the Constitution. The basic thing, what are writs? Here the writs are the written order issued by the Supreme Court and the High Court for enforcement of fundamental rights. This is simple. It means a written order. There are 5 different kinds of writs issued by the court. These are habeas corpus, mandamus, prohibition, centriorari, and QUO-WARRENTO. This is a provision provided in the Constitution to protect fundamental rights of the citizens. For example, if the government or public enforcement agencies arrests any person without any valid reason or with some ulterior motive, then the person can approach the Supreme Court by filing a writ petition, that is habeas corpus, questioning the arrest by the government. This is his fundamental right provided in the Constitution itself. So this is a simple example to provide you the importance of this writ petition in enforcing the fundamental rights and protecting them from being violated. Here the Supreme Court and High Court has different jurisdiction when it came in the matter of writs. Supreme Court has the power to issue writs for enforcement of fundamental rights only, whereas the High Court has the power to issue the writs for enforcement of fundamental rights as well as the other rights, that is a common legal right. So here the jurisdiction of Supreme Court is very narrower when compared to the High Court. This is a very important point for preliminary examination. And second is territorial jurisdiction. Supreme Court has a jurisdiction throughout the territory of India, whereas the High Court has a jurisdiction to their respective territories only. That is, the Karnataka High Court has territorial jurisdiction limited to the state of Karnataka. Here the Supreme Court has wider jurisdiction when compared to the High Court in case of territorial jurisdiction. And third point is Supreme Court cannot refuse to issue writs under Article 32. This is a fundamental rights provided to the citizens of the country to approach Supreme Court directly for the enforcement of their violated fundamental rights. So Supreme Court has sacred obligation to protect fundamental rights of the citizens through Article 32 by way of issuing writs. But the power provided in the High Court in Article 226 is discretionary. That means High Court can and may refuse to exercise the writ jurisdiction, but the Supreme Court cannot refuse to exercise the writ. This is a fundamental right, and this is a fundamental obligation of the Supreme Court. So let's move into detail about those 5 writs that I have mentioned earlier. The first is habeas corpus. It's a Latin term which means to have the body of. Habeas corpus is an order issued by the court to a person who has detained another person to produce the body of the latter before it. That means if the government or a private individual arrests or detained any person illegally without any valid reason, he can approach the Supreme Court or High Court by issuing habeas corpus writ petition and get the remedy from the court. And this writ is very important to protect individual liberty against arbitrary detention. And this writ can be issued against both public authorities like police forces or enforcement agencies, bureaucracy, and also the private individual. But there is a restriction provided in the article for issuing these writs. These writs cannot be issued when the detention is lawful, when a person is detained for contempt of court or contempt of legislature. That means if a person brought disrespect to the court or defamed the court or the legislature or parliament, this writ is not available to him. So next writ is mandamus. The meaning of mandamus is we command. So this is a command, that is order issued by a court to a public official, asking him to perform official duties that he has failed to perform or he has refused to perform. That means if any public official, take for example an election commissioner, has not performed the official duties, court can issue mandamus and direct him to perform the duties designated to him according to the Constitution and also the rule book. And this power to issue mandamus is available against the public body, a corporation, inferior court, tribunal, government for the same purpose. But this mandamus cannot be issued against the private individual or to the institution which does not possess the statutory force, means the institution which was not created under a statute, when the duty is discretionary, that is optional. And this mandamus cannot be issued against the governor or president or chief justice of a high court acting in judicial capacity. So the summary is mandamus is an order issued by the court to a public official to perform his duties as part of his official obligation which he is not performing. The next is prohibition. It means to forbid. And this writ is issued by higher court to the lower court or tribunal to prevent the lower court from exceeding its jurisdiction or usurping a jurisdiction that it does not possess. That means if the lower court oversteps its powers, then the higher court can issue the writs of prohibition to prevent that lower court to remain within the limits of the Constitution and also rules provided in the law. So the difference between mandamus and prohibition is mandamus directs the activity, whereas prohibition directs inactivity. Inactivity, it directs the court not to act in a certain way. And this prohibition can be issued only against the judicial and quasi-judicial authorities, means institution of judicial character, like courts, tribunals, and it is not available against the administrative authorities, legislative bodies, and private individuals. So this prohibition is issued against the institutions with judicial characters and not with executive, legislative, or private individual. This is important for prelims point of view. Please note it. The next writ is Certiorari. The term Certiorari means to be certified or to be informed. So, like prohibition, it is also issued by higher court to a lower court or tribunal, either to transfer a case pending within the lower court or to squash the order of the lower court. So, whenever the lower courts or tribunal commits mistakes, higher court has the power to issue Certiorari and direct the lower court to transfer a case pending with the lower court or to squash the order issued by the lower court. And it is issued on the grounds of excessive jurisdiction or lack of jurisdiction or error of law. And Certiorari can be issued as a preventive measure as well as the curative measure. And here Certiorari is issued against judicial, quasi-judicial authorities as well as administrative bodies. But this is not available against legislative bodies, private individual, and other bodies. So here, like prohibition, it is confined only to the judicial and quasi-judicial bodies. The next writ is QUO-WARRENTO. It means by what authority or by what warrant. It is issued by the court when a person occupied a public position illegally. Here, it is issued by a court to inquire into the legality of claim of a person to public office. As I mentioned, it prevents illegal assumption of public office by a person. And this writ is available only in case of substantive public office of permanent character created by statute or by the Constitution. That means the public office like CAG, Comptroller, Auditor General, or Election Commission of India, or chairman and membership of the UPSC, State Public Service Commissions. These are all the offices created by Constitution. And this writ can be issued against the persons occupying this constitutional position. QUO-WARRENTO cannot be issued in case of ministerial office, that is the ministers, or private offices like CMD of Wipro or Infosys. So these are all the 5 writs that are issued by the High Court and the Supreme Court for enforcement of fundamental rights, and this is a legal remedy guaranteed by the Constitution itself to protect the fundamental rights of the citizens. So whenever a person occupies a public position illegally, the remedy can be sought with the application of writ petition QUO-WARRENTO to the Supreme Court. And when the government or the private individual arrests any person without any valid reason, then habeas corpus can be filed in the Supreme Court. And when a public official fails to perform or refuses to perform his official duties that is provided in the Constitution as well as the rule books, Mandamus can be issued against him by the courts to perform his duties. So these are all the importances of these writs issued by High Court and Supreme Court. Thank you. Thanks for watching. Please subscribe.